All rise. Oui, vous levez. The International Criminal Court is now in session. Lord John de Cour Panel International at 08. Please be seated. Veuillez vous asseoir.
Good morning, everyone. Madam Court Officer, can you kindly mention the case?
Good morning, Madam President, Your Honours. The situation in the Central African Republic 2, in the case the prosecutor versus Mohamed Said Abdelkani, case reference ICC 0114-0121, and we are in open session.
Thank you very much, Madam Court Officer. Can I ask the parties to introduce themselves, starting with the prosecution?
Bonjour. The Deputy Prosecutor, thank you. Good morning, Madam President, Your Honours. The OTP is represented today by myself, the Deputy Prosecutor. Mohamed Nyang, beside me, is the Senior Trial Lawyer, Olo Makwaya. As well, with me today, Mr. Thomas B. Foley, Marie-Jeanne Saldacci, Brunhuld, Le Bailly, and Vanessa Gray. With me as well, Sanya Dagire and Anusha Rao. A number of analysts are with us as well. Alicia Vitella and Hilary Dyer. Thank you.
Thank you very much, Mr. Prosecutor. Representative for the victims, Ms. Pele, can I hear you, please?
Merci, Madame.
Ms. Pele, thank you, Madam President. The victims are represented by Gilles Dibert Bekoy, who's beside me, by Kars van Litsenborg and Adeline Beduda, as well as by myself, Sarah Pele, OPCV.
Thank you very much, Ms. Pele. For the defense, Ms. Nari, please.
Ms. Naori. Thank you, Madam President. Good morning. Beside me, Mr. Jacobs, Mr. François Jacquemin. Behind me, Emma Conti, Emma Rouhouk, Agathe Saint-Giron, close by, Norwen Oreke, Nolwen Monique. And as for myself, I am Jennifer Naouri, lead counsel, representing Mr. Said.
Thank you very much, Ms. Naouri. And for the record, I do take note that Mr. Said is in court with us. A very good morning to you, Mr. Said. I hope I see you well.
Mr. Said. Yes, good morning, Madam President.
Good morning. I welcome everyone in and around the courtroom, as well as those following online, in particular those in the Central African Republic, to this hearing. Now, over the next few days, we will hear the closing statements of parties and participants in this case. As set out in the fourth direction on the conduct of proceedings and the scheduling order for the closing statements, we will start with the prosecution, which has been allotted 90 minutes to respond to any specific points raised in the defense's closing brief, followed by 60 minutes to summarize its case and make final submissions. We will then hear from the common legal representative of victims, who has 30 minutes for her final submissions. The chamber will then adjourn for the day, and we will hear from the defense tomorrow. Before I turn to the prosecution, I have a few housekeeping matters to bring to your attention. Now, the registry will be monitoring the time and will inform the chamber when the allotted time is due to end. Furthermore, the chamber expects the parties and participants' submissions to be in public session. In this regard, the chamber recalls its directions in relation to the closing briefs, in which it allowed the parties and participants to refer to confidential information as long as doing so does not lead to the identification of protected witnesses or otherwise compromise their security. Lastly, I remind everyone of the importance to speak slowly for the interpreters and court reporters. With that, I give the floor to the prosecution.
Merci.
The Deputy Prosecutor. Thank you, Madam President. Madam President, Your Honors, in a number of weeks, to be more specific, on the 28th of December, the Central African Republic will be organizing an election with a view to choosing new representatives for the Republic's institutions. It is fortunate that as this country, still devastated by the civil war that occurred between 2012 and 2014, is attempting to end this painful chapter in its history, it is fortunate that the International Criminal Court is present. The court is here, and perhaps there has been a postponement or a bit of a lag, but we are not late. I can say that those who lived through this conflict, I can say to them that winning or retaining power cannot justify massacring part of the population, a group of people within the population who are reduced to their ethnic or religious identity and deemed to be an enemy of the people, depending on one's political affiliation. I've spoken of political affiliation and political groups. I'm referring to the Seleka and the Anti-Balaka. Madam President, Your Honors, I was here in this very courtroom only 2 months ago to hear the verdict that was handed down in the Yekatom Ngaisona case. Two figureheads within the Anti-Balaka group. Today, it is my honor to lead the OTP team that will be presenting our closing submissions regarding a figurehead of the other faction, Mr. Mohamed Said Abdel Kani. The charges that we filed against Mr. Said relate to unspeakable violence and persecution against people deemed to be pro-Bozizé or perceived as being Bozizé supporters, as well as atrocious crimes perpetrated by the Seleka in 2003, particularly in Bangui, the capital. In our various filings to your chamber and throughout the course of our submissions during this trial, the prosecution has adduced solid evidence showing beyond reasonable doubt that the accused person, Mr. Mahamat Saeed Abdelkani, perpetrated, with others, ordered, or encouraged 7 counts of war crimes and crimes against humanity, the crimes that have led to his appearance before this court. Madam President, Your Honors, my colleague, Ms. Maguire, will explain to you exactly how the evidence demonstrates and proves the charges standing in Mr. Saeed's name. My colleague will also respond to a number of specific points found in the defense's closing brief. Once again, I must stress that this phase of the proceedings, the closing submissions, is a very important part, a very important stage in the case. We find ourselves closer and closer to the decisive moment, namely the establishment of the judicial truth regarding the very serious crimes that Mr. Saeed has been charged with. More than ever, carrying out prosecuting Mr. Saeed and determining who was responsible for the painful events that ripped the Central African Republic apart between 12 April and 30 August 2013. More than ever, this prosecution is necessary. Throughout the course of this trial, our office has never changed course. We have done all we could to ensure that justice is served for the victims of the atrocities perpetrated in the situation by all parties to the conflict. If we have made progress in these proceedings, it is thanks to the essential contribution of key stakeholders. In 121 days of hearings, you have heard the accounts of 81 witnesses. 25 appeared here in the courtroom, and you heard them viva voce. 33 provided evidence by virtue of the Rule 68.3 mechanism. This was a tremendous amount of work, and it could only be done thanks to the participation of everyone, particularly the victims and the affected communities in the Central African Republic. They worked together with us, showing courage and determination, and this with a view to achieving justice. Authorities within the Central African Republic, stakeholders from civil society, and other people were all part of this task. Madam President, Your Honors, throughout this trial, which began on the 26th of September 2002, and as I said earlier, the prosecution has presented solid evidence, and we have established beyond reasonable doubt that the accused person, Mr. Saeed, perpetrated, ordered, or encouraged the crimes that are set out in the 5 counts. 5 counts of war crimes and crimes against humanity committed by the Seleka faction. Where did the crimes occur? What was the crime scene? The crimes occurred at the OCRB, the Central Office for the Repression of Banditry. It has been determined beyond reasonable doubt that Mr. Saeed was responsible for these serious crimes. He made an essential contribution to a common plan with other high-ranking members of the Seleka coalition. These crimes targeted people who were deemed to be Bozizé supporters, who were arrested, detained, and abused at the OCRB. They were subjected to all kinds of mistreatment. You will hear from my colleagues exactly what role was played by the accused, Mr. Said. As a high-ranking member of the Seleka coalition, he was the one leading the operations within the OCRB. The prosecution will hark back to key points that were determined during the testimony from the OTP's witnesses who were subjected to horrific abuse committed by Mr. Said in the Seleka when arrested and when detained at the OCRB. The prosecution will show written documentation signed by Mr. Said himself, documents that show that he had complete control over the victims detained in inhumane conditions at the OCRB. You will hear passages from their testimony that establish that he took part directly in the abuse. The victims of these crimes were targeted. And why? They were arrested arbitrarily for reasons of politics, ethnicity, religion, or gender. The evidence in this trial demonstrates that the victims of the crimes committed by Mr. Said were mostly of the Christian faith. They were male. They belonged to the Baya, Manja, or Banda ethnic groups for the most part. They lived in the neighborhoods, in certain neighborhoods of Bangui, such as Boirab. Your Honors, the events that the prosecution have described to you occurred as part of a non-international armed conflict that took place in Bangui during intense hostilities between Seleka and the pro-Bozize forces between late 2012 and the 10th of January 2014 at least. The prosecution has established that during these hostilities, women, children, the elderly, and disabled people fell victim to the horrific acts of abuse and violence committed by the Seleka. Amongst the many victims, we find women who had been raped, sometimes in front of their very own children, because they were deemed to be, or rather, their husband was deemed to be a Bozize supporter. Young children, barely 4 years old, had to undergo amputations after a device blew up when thrown at a church in a neighborhood that was deemed to be a pro-Bozize neighborhood. The severe suffering of all these victims and their family members still echo in this courtroom. The expectations for justice can still be read on the faces of these victims. Today is a turning point, and it is of crucial importance in the eyes of the victims, the affected communities, and the people of the Central African Republic who have waited so long for justice. In this case against Mr. Mohamed Said Abdelkani, I am confident that justice shall be rendered after our submissions and those of the various parties, which will be heard today and tomorrow. I thus conclude, and I would now like to ask my colleague, Ms. Maguire, to take the floor. Once again, I thank you, Your Honors.
Thank you very much, Mr. Prosecutor. Ms. Maguire, please, can we hear from you? Ms. McQuire, just a moment. Maybe let's have a correction to the transcript. I don't know the right reference point, but I'm made to understand that both in the French and English version of the transcript, we have at a particular line 13 the mention of the year 2014. I think the prosecutor was trying to talk in respect of responsibility for the offenses committed in the Central African Republic between the period 12th April and 30th of August. But the year that we have there is 2014. Can you confirm whether or not you meant, Mr. Prosecutor, 2014 or 2013 of August?
C'était bien 2013, Madame la Présidente.
Indeed, Your Honor, it was 2013.
Thank you very much for that clarification.
Parce que la période que nous...
The period in question is in the year 2013.
Thank you very much for that clarification. Ms. McQuire, please, can we hear from you?
Thank you, Madam President. Your Honors, good morning. Before I proceed, Madam President, a bit of a housekeeping matter. Our evidence channel is not working. At this portion of our presentation, we won't be showing any slides, but we missed the opportunity to show a few with the DP. If we could be assisted, we'll be grateful.
The court officer will come to your rescue in that regard. Thank you.
Before I start, Your Honors, I would like to delineate the manner in which we shall be proceeding with addressing some of the issues raised by the defense in their closing brief. I shall start by addressing you on some issues related to evidentiary matters. I shall be followed by Ms. Anusha Rawa, who shall address issues with respect to the non-international armed conflict, who will be followed by Ms. Marie-Jeanne Sardachi, who will address you on 4 incidents. And we shall finish with Mr. Thomas Bifoli, who shall address you on matters raised with respect to the mode of liability. And then when we come to the prosecution case, I shall be summing up with Ms. Sanyu Ndagiri. Having said that, Madam President, I shall now start. Madam President, Your Honors, the defense has raised multiple issues and assertions with respect to the knowledge of Mr. Said on the running on the constitution of the former led Seleka government and even the coalition. We have a very simple answer to that, Your Honors. This case is not a case against the Seleka coalition. It is not a case against the government led by the Seleka coalition. It is the case against Mr. Mahmoud Said Abdel Khani for his act and conduct during the charged period. Whereas you've heard from Mr. Prosecutor, he faces 7 counts. I will start with an evidentiary issue also repeated continuously in the defense brief with respect to the evidence presented by the prosecution that it claims lacks corroboration, lacks or contains inconsistencies in support of its general contention on the weakness of the prosecution evidence. The defense, Madam President, Your Honors, also takes issue with what it deems the lack of forensic evidence, therefore weakening the presented case. Your Honors, here again our position is quite simple. These issues are settled in law, and Your Honors have a broad discretion when you come to the assessment of the evidence presented before you, because you will do so in a holistic manner to issues pertaining to credibility and the reliability of witness evidence. Further, Madam President, corroboration is not required as a matter of law. And here I would like to refer Your Honors to the Lubanga appeal judgment at paragraph 218, the Bemba et al. Appeal judgment at paragraph 1084, and also an appellate decision in Gujolo at paragraph 184. And even the Rome Statute does not require corroboration before Your Honors can consider a piece of evidence. Madam President, Your Honors, inconsistencies in witnesses' evidence we submit constitute no bar to reliability. And again, I would refer you to the same appellate decisions, starting with Ngujolo in support of this assertion, para 168, then Taganda appeal judgment at para 806. Now, with respect to whether or not the lack of forensic evidence weakens the prosecution case, Madam President, the answer is no. Forensic evidence is not required to prove a crime falling within the jurisdiction of the statute. And here, Your Honors, I'd like to refer you to the Ongwen trial judgment at paragraphs 1471 to 1472. We also refer you to the Musema trial judgment and sentencing at paragraph 52. I forgot to inform Your Honors, all these decisions are listed in our Book of Authorities for your ease of reference. Madam President, in assessing the evidence that has been presented before you, Your Honors would recall that many of the witnesses during the trial were victims of Said's horrendous crimes. For example, P547, 481, and others you had the opportunity to hear. In this regard, we shall also recall the jurisprudence available that states the impact of trauma and the passage of time may have a contributing factor to a witness's recollection. Both these factors can be, Your Honors, a source of unclarity in the evidence that is given. We submit, Your Honors, that when you assess the totality of the prosecution evidence, you should give due consideration and appropriate allowance in factoring in all these indicia that may impact the testimony of a witness. The evidence should be assessed in its entirety, holistically, and not piecemeal. I here refer you to the constant case law we also cited in our table of authorities, found in Bemba et al. Trial judgment at paragraph 203, also in the Al-Hassan trial judgment at paragraphs 40 to 41, in the Yekatom and Gaisona trial judgment at paragraph 201, and again in the Ongwen trial judgment at paragraph 258. Your Honors, it's our submission the defense adopted a fragmented approach to the evidence led by the prosecution. It has dissected the evidence to feed into an argumentative line which is not supported by the law, and as a result, their assessment failed to pierce the solidity of the body of credible and reliable evidence presented by the prosecution during the trial that we submit establishes Mr. Said's responsibility in the crimes as charged. I will only refer you to the paragraphs where these contentions are made in the defense brief, Madam President, in the interest of time. I'm quite aware we've got very limited time. These allegations or assertions made by my friends across the bar can be found at paragraph 95, 120, 127, 137, 417, 142, etc., with respect to corroboration. And again, paragraphs 317, 324, 328, 433, etc., on inconsistencies. Now, with respect to the lack of forensic evidence, this is also mentioned at paragraph 4. Madam President, Your Honors, you may recall the evidence of Mr. Prosecution Investigator, who clearly testified that it was not always necessary to conduct forensic evidence if other pieces of direct and corroborated evidence existed. And he gave an example of a particular incident where he was being cross-examined on. In conclusion on this topic, Madam President, it's our submission that the defense assertions pertaining to issues which are in fact some of the many pertaining to issues which may be impacted by some of the many factors you will find in the cited case law should be taken into consideration when you do a holistic review of the prosecution evidence and not undertake the approach taken by the defense of isolating or dissecting line by line, piece by piece. I shall now turn, Your Honors, to another issue raised in the defense brief with respect to incidents D and K. Your Honors, recently on the 20th of October 2025, we clarified to the Chamber that incident D and K are properly before the Chamber and the prosecution has no intention whatsoever to withdraw these incidents for your consideration when you make your deliberation with respect to the evidence you've heard. Both incidents are found in the DCC, have been confirmed by the pretrial chamber at paragraph 29D and K of the decision on the confirmation of the charges. As we identified in the clarification response, Madam President, there is evidence on record, ample evidence on record to establish both incidents. Granted, Madam President, Your Honors, the two victims of these allegations did not appear before you because they declined to testify for the reasons we presented to the Chamber. Nevertheless, the allegations have been proved. The allegations have been proved with the other evidence that is available on record. As for the contention concerning the absence of evidence on Mr. Said's role and responsibility in relation to both these incidents, the prosecution refers the Chamber to the evidence mentioned in paragraphs 105 and 123 of its closing brief on Mr. Said's role at the time of relevance to the charges. Based on this evidence, Your Honors, it is our case that a reasonable inference can be drawn on Mr. Said's individual criminal responsibility in relation to the detention of P0645 and P2172 at the OCRB. I shall now turn to another issue raised by the defense, and this time, Madam President, Your Honors, it's with respect to SEDAD as a non-charged incident for the purpose of the contextual elements of crimes against humanity. Your Honors would recall that evidence related to the SEDAD has been set out in paragraphs 72 to 75 of the prosecution's closing brief in the section on contextual elements of the crimes against humanity. The defense asserts at paragraph 144 and 146 of its brief that the prosecution reintroduced charges by considering evidence on the SEDAD to establish that an attack took place pursuant to Articles 7.1 and 7.2 of the statute. This defense position, Madam President, Your Honors, is in apostate. The prosecution did not reintroduce the charges by considering evidence on Sedad. As set out in the court's jurisprudence, it is permissible for the chamber to consider non-charged incidents for the purpose of an attack pursuant to Article 7.1, providing they fall within the temporal and geographical scope of the charges. We refer, Your Honors, here to the decision on the confirmation of charges in the Ntaganda case, also in our Book of Authorities, more particularly at its paragraph 23. After all is considered and said, Madam President, Your Honors, the defense at the end of the day has been on notice. The defense has been on notice of the temporal and geographical scope of the attack under consideration by Your Honors at paragraph 60 of the confirmation of charges decision and at paragraph 50, and I'll stop there, at paragraph 60 of the confirmation of decision of the charges. This took place in 2021. They've been on notice, ample notice, for more than 2 years. And I will just give a bit of context, Madam President. This attack is described as a cause of conduct taking place from at least April 2013 until at least November 2013 against the civilian population in Bangui perceived to be Bozize supporters. So it's covered by the temporal scope. Your Honors, in the case at bar, this contention does not warrant any further consideration. There is no doubt that the detention and ill treatment of perceived pro-Bozize supporters at the Sedad between mid-September 2013 to 8th November of the same year in Bangui falls squarely within the temporal scope and geographical scope of the attack, as defined in paragraph 60 of the confirmation of charges decision. I shall conclude on this point, Your Honors, by stating that the prosecution committed no error in arguing that this non-charged incident forms part of the Seleka attack, which took place against perceived pro-Bozize supporters in Bangui from at least April 2013 to November of the same year. I'm now turning to another contention raised by the defense in its brief, and this time it's with respect to the scope of application of counts 2 to 4. At paragraphs 562 and 563 of its closing brief, the defense contests the scope of application of counts 2 to 4 as summarized in the closing brief. It contends, Your Honors, that the pretrial chamber only confirmed counts 2 to 4 in relation to 5 incidents. And these are incident B, E, H, M, and Q. Madam President, Your Honors, the defense proposes an erroneous reading to the charges we submit. Counts 2 to 4, as formulated in the decision on the confirmation of the charges, contains a non-exhaustive list of the confirmed incidents. And I'm going to repeat this. It contains a non-exhaustive list of the confirmed incidents, including as summarized in quotation mark, which are now under consideration by Your Honors chamber. Going back to the decision on the scope of the charges, ICC-01/14-01/21-472 at paragraph 25, Your Honors, you have confirmed that the scope of the charged crimes in the present case is limited to the specific incidents listed in the confirmation decision. However, for the purposes of counts 2 to 4, this includes not only the victimization expressly mentioned therein, but also the victimization of other persons, provided, Your Honors, and we put emphasis there, other persons, provided they were also listed in paragraph 29 of the operative part of the confirmation decision. Your Honors, according to the pretrial chamber, the scope of counts 2 to 4, moreover, was not limited to the incidents listed in the confirmation decision. An interpretation supported by the trial and appeals chamber in Ntaganda. Would like to refer Your Honors to the pretrial chamber's decision at ICC-01/14-01/21-396, paragraphs starting 16, ending at 25, and also to the appeals judgment in Ntaganda at paragraph 326, and the trial judgment in Ntaganda at paragraphs 37, 40, and 41. Subsequently, Your Honors, it's our submission that the defense contention should not be given any further consideration. In its brief, Madam President, Your Honors, the defense has also mischaracterized or conducted an assessment of the presented evidence by prosecution witnesses in a flawed manner. It has repeatedly mischaracterized the evidence in an attempt to discredit the evidence presented by the prosecution to establish the crimes charged. Your Honors, in the 81 witnesses presented before you, we presented a solid body of evidence for your consideration when you retire to deliberate. We have only chosen a few salient examples from the defense brief to demonstrate the flaws or the mischaracterization of the evidence they've undertaken. For example, Madam President, at paragraphs 180 to 184 of the defense closing brief, the defense contends that P1339 did not know what was happening in Zongo, nor participate in the discussions between soldiers The manner in which this assertion is put forward totally mischaracterizes the evidence of the witness. It took a line of one of his responses to a question and then ran with it. The evidence on the anti-Balaka has been assessed in isolation. Once again, not in the totality of the witness's entire evidence, hence the flawed assessment by the defense. You may recall, Your Honors, that this witness testified that after the March 2013 attack, he fled to Zongo, where he saw soldiers discussing among themselves. While he was not aware of everything that was going on, he testified about his interactions with the individuals that ultimately led him to join the anti-Balaka. And here I would refer you to transcript 131, comma 23, column 10-22. We do not want to delve any further into the evidence of this witness. Now, turning to paragraphs 5, 20, and 24 of its closing brief, the defense also contends that witness P547, that the account of witness P547 contains no reference to Mr. Said, the accused before you today. This, we submit, is another mischaracterization of the evidence. P547 testified that he saw Said on several occasions at the OCRB, identified him on photographs shown here in court, as referred to in paragraph 219 of our closing brief, and testified, Your Honors, at length before you about his role and control over the detainees at the OCRB. Your Honors, here we refer to excerpts of transcript T12 and T13, or submitted to you before this hearing. Madam President, P547's evidence needs to be assessed in the context of other evidence on detentions at the OCRB at the time of the charges. For instance, his evidence on the underground cell is corroborative of the evidence of numerous prosecution witnesses, such as P3056 and P2478, to cite just a few. Your Honors, I submit that the defense not only failed to consider the evidence in its totality, but it also presented an erroneous reading of the evidence in support of its assertions. Having said that, Madam President, this concludes my part on the defense brief, and I now invite Ms. Anusha Rawa, who shall be speaking to issues raised with respect to the non-international armed conflict. Thank you for your attention.
Thank you very much, Madam Prosecutor. Ms. Yawawa, we'll listen to you, please. Thank you.
Thank you, Madam President. Your Honors, good morning. My submissions today address the principal issues arising from the defense brief, notably on war crimes. As the Chamber is aware, the prosecution's full position on war crimes is addressed at pages 5 to 27 of the prosecution's closing brief. Your Honors, the defense arguments on war crimes fall in four broad categories. First, the evidentiary weight to be attached to the testimonies of defense witnesses P0015 and P0022. Second, the alleged lack of organization of the anti-Balaka and the Seleka. Third, the defense contention that there was no armed confrontation existing prior to September 2013. And fourth, the defense submissions on Mr. Said's knowledge. Your Honors, I now turn to the first issue. Your Honors, at paragraphs 157 to 165, the defense contends that the prosecution delivered its narrative without presenting the witness with facts. Respectfully, Your Honors, the prosecutions disagree. Regarding P0015, Your Honors will recall that the witness was called as a witness of facts. The witness was duly confronted with all the relevant facts during cross-examination. However, her answers revealed significant gaps in knowledge concerning factual matters. And for this, I refer Your Honors to the English transcript T136, pages 4 to 6. In those
In this transcript, you will recall, Your Honor, P0015 admitted having no information at all as to whether any peace agreement was signed between the Anti-Balaka and the Seleka after the March 2013 attack. She even had no knowledge as to what had happened to the pro-Bozizé forces after they had fled. In fact, she admitted that her research focused on the armed elements which remained in the country. Likewise, Your Honours, for P0022, the same deficiencies apply. This witness was also a witness of fact. He came to testify, yet he had no meaningful knowledge as to the events related to this case. Your Honours will recall that the witness was in the Central African Republic for only 2 weeks. And I'll here refer his responses in transcript 134, the English version, pages 57 and page 70. The witness admitted never having even heard about the OCRB. The witness said he had no knowledge about the Seleka bases in Bangui. By contrast, Your Honours, we have on record overwhelming evidence from insider witnesses as well as victims, which contradict the defense version on every material point. I refer by way of example here the evidence of P0291, P2232, P1339, and other Seleka insider witnesses such as P2105, P1167, and P2563, whose evidence give us an aperçu on what had happened actually in the Central African Republic in 2013, and as well as matters pertaining to their personal knowledge. Therefore, Your Honours, prosecution submits that neither of these two defense witnesses were capable of undermining, at any rate, the substantial evidence on record from prosecution. This now brings me to the second issue, the alleged lack of organization of the Anti-Balaka. It is defense contention, Your Honours, at paragraphs 180 to 184 and 223 to 228, that the Anti-Balaka lacked the organization, structure, logistical, or operational capacity. Your Honours, the evidence demonstrates the opposite, and this for the following reasons. First, it is prosecution submission that the pro-Bozizé forces, which later became the Anti-Balaka, maintained an effective command structure adapted to their circumstances. It is not disputed that prior to the 24th of March 2013, Bozizé commanded the state armed forces, namely the FACA. Therefore, these forces already enjoyed the legal presumption of sufficient organization. Now, referring to the case of Dilalich, trial judgment, paragraph 231, the prosecution submits that whatever the precise legal classification of these forces loyal to Bozizé, in the immediate aftermath of March 2013, they represented part of the same party that had been subject to Bozizé's control. That is, the party opposing the Seleka. Your Honours, after the 24th of March 2013 attack by the Seleka, the pro-Bozizé forces had set up a command structure with military commanders. They were known as the Comzone, and you have heard P2232's testimony on this. He testified that this term was copied from the military model. I'll here refer, Your Honours, to the transcript T02, pages 33 and 37, the English transcript, where P2232 explained that Mokom was the coordinator of operations. And I quote, he prepared the Comzones for the attacks. He taught them combat tactics on the phone. The Anti-Balaka leaders were able to communicate among themselves through telephone, and they were able to coordinate. Using the words of P1339, there were very good communications among the Comzones. The pro-Bozizé were organized into sections, as explained by P1339 in English transcript T1 132, pages 19 and 20. And they were also identified by Gris-Gris. In all, Your Honours, the clear objectives of the anti-Balaka was to drive the Seleka out of the country and regain power from them, as explained by P2232. My next point is that contrary to what defense asserts at paragraphs 217 to 220, the pro-Bozizé forces did have the logistical capacity. They had the capacity to train and recruit new elements. P1339 testified that after retreating to the provinces, volunteers joined and they were trained on how to use weapons. They were in fact trained by former FACA soldiers. Weapons were therefore provided to the members, and as explained by P2251 and P0342, the anti-Balaka used weapons, albeit traditional weapons, fashioned by themselves, arrows and knives. They had pan lids, they had grenades during the attacks with the Seleka, as explained by P2251. The pro-Bozizé forces, Your Honours, also made use of various means of communication. As submitted, they made use of telephone, they also made use of emails. And I will here refer to the several email communications of key actors between March and November 2013, showing the pro-Bozizé forces eventually taking steps to reorganize, resupply, and rearm their forces. And here, paragraph 41 of the prosecution closing brief addressed this issue. My next point is that, contrary to defense assertions, the pro-Bozizé forces had the operational capacity to carry out military attacks. Your Honours, the reorganization of the pro-Bozizé forces after March 2013 actually assisted them to coordinate attacks. Your Honours heard evidence that on 18 August 2013, the pro-Bozizé forces launched an attack at the National Assembly in Bangui to disrupt the second inauguration of Georgia. Actually, Your Honours, the pro-Bozizé forces had the capacity to act on the intelligence collected, which they used during the attacks. And as explained by the former Prime Minister of Central African Republic, P0291, the anti-Balaka had organized themselves in the provinces, and they launched several attacks between August and September 2013. Additionally, Your Honours, contrary to what defense contends, that there has been inadequacy of funding of the anti-Balaka forces, prosecution submits that there is evidence on record about the funding to this organization. As explained by P2232, funding came to the anti-Balaka from the House of Mokom being provided as guarantee, as well as money transferred from Cameroon. I'll here refer to his testimony at English transcript T102, pages 40 to 41. He further explained, and I quote, they would get money because during fighting, some would flee and leave their goods behind, vehicles or other possessions. So they would use those things to get money. Therefore, the prosecution submits, Your Honour, based on these evidence adduced, the pro-Bozizé forces were duly organized. I now turn to the next point, the defense contention that the Seleka lacked organization. Prosecution submits, Your Honours, that at all material times, and even before the capture of Bangui in March 2013, the Seleka was sufficiently organized so as to establish the existence of a non-international armed conflict. I'll here refer, Your Honours, to paragraphs 21 to 31 of the prosecution closing brief. First, the prosecution submits that the Seleka did have the capacity to conduct military operations. Your Honours heard evidence from Seleka insiders that in March 2013, Seleka leaders, including Chetoja, met at Sibut. They planned and coordinated the attack to capture Bangui. The Seleka elements then marched towards Bangui and entered the city from different directions. And here, the exhibit bearing reference car REG 0002-0035 becomes relevant, which is the map on which P2105 annotated regarding the routes which the various commanders took with their troops down to Bangui. On 24th of March 2013, the Seleka launched an attack on Bangui. They overthrew the Bozizé government. This shows the Seleka's military capacity to carry out a coordinated operation, leading to even overthrowing a government in power. My next point is that the Seleka controlled an important territory in Central African Republic, including its capital city, Bangui, by 24th March 2013. Your Honours, after the Seleka had taken power in March 2013, they started controlling an even more substantial territory of the Central African Republic than before. They had then set up a checkpoint system to control movement of people within their territory. I'll here refer to the Bourabe incident in April 2013 and the PK9 checkpoint incident in July 2013, where the Seleka blocked entry and exit points with armed men, preventing the population from escaping violence. To maintain their power, the Seleka established various bases, such as the OCRB Central, OCRB Ngoussiment, Cedad, Camp de Roux, Camp Kassai, and Sapeurs-Pompiers. Your Honours, another factor borne out by evidence is that the Seleka had a proper command structure. The evidence on record shows that before he became president, Chetoja, the leader of the Seleka, was even giving orders to Seleka members, and they were being complied with. For instance, you have heard insider witnesses P2563 and P1167 stating that the March 2013 attack was carefully planned and that instructions came from Chetoja. Your Honours, upon gaining power, the Chetoja-led government appointed Seleka members to key posts, such as Security and Finance Ministry. This was done through official presidential decrees. I'll here refer Your Honours to the CAR Presidential Decree CAR OTP 2004-1597. A National Security Council was also established through a presidential decree. And senior Seleka officials were holding weekly meetings to assess the security matters in the Central African Republic. My next point, Your Honours, is that there is also evidence on record that the Seleka had significant logistical capacity. On this, Your Honours heard several witnesses, namely P0338, P3056, P1339, P2563, who explained that during the March 2013 attack, the Seleka were well equipped. They had military-type vehicles, weapons, and other equipment. Several photographs have been adduced as evidence, such as the photograph bearing reference number CAR OTP 2074-1124, as well as CAR OTP 2042-4942. P2105, in fact, testified that each Seleka troop had an AK-47 and heavy weapons used by the Seleka. They possessed satellite phones, the Turayas, which the Seleka leaders used to communicate among themselves and plan the advance upon Bangui. The Seleka were also provided with identification badges issued with stamps of Seleka and signed by Adam. I'll here refer to the identification badges on record for P2105, P1737, and P2563. Moreover, Your Honours, there were military camps, training camps established by the Seleka to provide training to the elements. The Seleka had a system of food distribution across the bases, and uniform arrangements were made for them. The OCRB Seleka also wore uniform and blue armbands. Your Honours, all these evidence on record clearly demonstrate that the Seleka did have a command structure and military capacity to carry out successful operations. I now turn to the third point of contention by the defense, that there was allegedly no armed confrontation between the Anti-Balaka and the Seleka until September 2013. At paragraphs 243 to 247, Your Honours, the defense argues that there was a lack of intensity of conflicts between 24th of March 2013 and end of August 2013. The prosecution respectfully disagrees. Your Honours, it is settled law that the intensity and protracted armed conflict criterion do not require the violence to be continuous and uninterrupted. Rather, the essential criterion is that it goes beyond isolated or sporadic acts of violence. I'll refer Your Honours here to the trial judgment of Bemba at paragraph 140. In the present case, as already submitted before, there was an initial conflict between the Seleka and the pro-Bozizé forces in the late 2012. This led to the attack in March 2013 and overthrowing of the Bozizé government in March 2013. Therefore, this initial conflict, Your Honours, transcended mere isolated or sporadic acts of violence. The conflicts were so intense that this even prompted the international community to intervene. A ceasefire agreement was signed between the parties on the 11th of January 2013, but it was short-lived. On this issue, Your Honours, I refer to the trial judgment of Danganda, paragraph 723, where it was held that the signing of ceasefire agreements is an indication that the situation being addressed by the agreement was of a significant intensity, which is precisely the case here. When the Seleka took power on 24th of March 2013, the pro-Bozizé forces did not surrender. They did not sign any peace agreement with the pro-Bozizé forces. The pro-Bozizé forces, on the other hand, regrouped. They went to the provinces, and as P2232 testified, the Anti-Balaka was formed a month or two after the Seleka took power on the 24th of March 2013. Therefore, Your Honours, the hostilities against the Seleka continued. And I'll here refer to the Boirabe incidents of April 2013, as well as to the incident, the attack on the 18th of August 2013 to prevent Chitoja from being sworn in. Subsequently, in August and September 2013, the pro-Bozizé forces launched several attacks, as explained by P0291. Many civilians were displaced, Your Honours, and this prompted the Seleka government to deploy 0291 to Bosangoa to address the situation. I'll now refer Your Honours to the trial judgment of Bemba, paragraph 141, where it was held that international humanitarian law applies from the initiation of an armed conflict and extends beyond the cessation of hostilities until a peaceful settlement is achieved. Until that moment, international humanitarian law continues to apply in the whole territory under the control of a party whether or not actual combat takes place. As submitted, Your Honours, when the Seleka took over power on 24th of March 2013, the pro-Bozizé forces did not sign any peace agreement with the Seleka. In fact, Your Honours, despite being in power, the Seleka were laboring under constant fear of attacks from the pro-Bozizé forces. This prompted the Seleka to monitor pro-Bozizé forces and gather intelligence on their activities. For instance, Your Honours, the Seleka members were sent on mission to Zongo by the then Minister of Public Security, Adam, in the period May to August 2013. The purpose was to collect intelligence on the activities of the pro-Bozizé forces. I'll refer here to the several ordres de mission quoted at paragraph 38 of the prosecution's closing brief. I also refer Your Honours to the different military intelligence reports which the prosecution has referred to at paragraph 25 of its closing brief. Your Honours will also recall that as per P0291, security meetings were being held on a weekly basis to address this situation. Consequently, Your Honour, prosecution submits that international humanitarian law continued to apply throughout the whole of 2013, including the charge period. I now turn to the final contention raised by the defense in their closing brief, challenging Mr. Said's knowledge on the existence of a non-international armed conflict between April and August 2013. Your Honours, based on the evidence submitted between 24th March 2013 and 5th of December 2013, the Seleka remained active in the Central African Republic. They continued to train the elements. They continued to exercise military power against the Central African Republic population as well as pro-Bozizé forces. And they left Bangui after President Jodoja had stepped down from his position. And that was on the 10th of January 2014. Now, regarding Mr. Said, after the Seleka had taken over Bangui in March 2013, he was appointed head of the OCRB by Adam, who was the then Minister of Public Security under the Seleka-led government. Therefore, Mr. Said's power flew directly from Adam. There is evidence on record that Mr. Said had cooperated with other Seleka leaders as of April 2013 in order to suppress resistance to the Seleka regime. In these circumstances, Your Honours, prosecution submits that neither Mr. Said nor any relevant factual perpetrator could have failed to know of the existence of an international armed conflict, of a non-international armed conflict. To conclude, Your Honours, defense contentions raised on war crimes in their defense brief hold no water in light of the substantial evidence adduced by prosecution. Therefore, the prosecution submits that, based on the evidence, it has proved beyond reasonable doubt the existence of a non-international armed conflict during the charge period, as well as the commission of war crimes within the meaning of Article 8 of the Rome Statute, as well as Mr. Said's knowledge to these war crimes. With this, I end my submissions, and I now pass the floor to Ms. Marie-Jeanne Sardachi. Thank you, Your Honours.
Can I please remind the parties in the prosecution to slow the pace, please, for the assistance of the interpreters. Please speak slower. Thank you very much.
Thank you very much, Counsel. Ms. Saudache, we have about 12 minutes to the first break, just for you to know. We will listen to you, please.
Thank you, Madam President. It should be over 15 minutes, so if you allow us to speed over the break a little bit.
I'm sure the registry would accommodate us and the defense would accommodate us if you need just 15 minutes. Please carry on.
Bonjour, Madame la Présidente.
Good day, Madam President, Your Honours. I'm going to respond to the arguments put forward by the defence relating to 4 incidents, which correspond respectively to paragraphs 29G, H, J, and N of the decision on the confirmation of charges against Mr. Said. Firstly, I'm going to talk about G and J, where 2 FACA soldiers died. The defense criticizes the absence of forensic investigative acts, and here I refer to paragraph 465, incident G of the defense submissions, and incident 485 as regards incident J. Although the prosecution has provided forensic evidence in certain cases, it still is true that the applicable law is clear and the case law consistent. Forensic evidence is not sine qua non a requirement to establish the existence of a crime before the court. I refer to the Rule 63.4 of the Rules of Procedure and Evidence and the judgment that was already quoted, so I won't repeat the details. As regards G, which is in paragraph 450 to 467 of the defense brief, the evidence shows that the soldier of the Central African Armed Forces was arrested in Bangui by Mr. Said and his agents. 2 key witnesses confirm this. P2504 saw Mr. Said and his men place the FACA soldiers in their vehicle, and he followed them to the OCRB. The other witness, P2607, who was a member of the family of the FACA soldier, described being stopped just before reaching the OCRB. Mr. Said came into the street, fired shots in the air, and instructed his men not to let P2607 and his family pass. Shortly thereafter, P2607 was able to identify his brother by recognizing his sweatpants, whose legs were protruding from the vehicle marked OCRB. I here refer to paragraph 20 and 21 of his statement. In the French version, car OTP 2125 0855. The fact that P2607 does not recall the price color of his brother's sweatpants of the soldier, or that there are some inconsistencies surrounding the date of the FACA soldier's death certificate, in no way undermines the totality of the evidence established in this incident. Regarding incident J, referred to in paragraph 483 to 492 of the defense brief, the prosecution relies in particular on the testimonies of 2 witnesses, P2021 and 3105. These are direct, detailed, and consistent. One of the witnesses describes with precision the scene of the arrest. It relates to the arrival, and here I refer to paragraph 101 to 203 of the written testimonies. These details are recorded in the morgue and also by the family, and therefore are verifiable. Furthermore, we have the Selector insider who confirms this. The 2 accounts overlap on all essential points: the role played by Mr. Said, the violence of the arrest, the detention of the 2 young men, and fit within a logical chronology. Their internal and mutual consistency established the credibility of the evidence beyond reasonable doubt. As regards Incident N, concerning a victim bound in the Achar manner and locked in a basement cell, I will address a few points raised by the defense at paragraph 507 to 513 of its submissions. At paragraph 507, the defense asserts that the evidence put forward by the prosecution regarding this incident is weak because it relies on a single testimony relating, and I quote, an unidentified person at an unidentified date, end of quote. The fact that the evidence rests only on one witness is not in itself an obstacle to a conviction. I will not repeat what the senior trial lawyer said in his introduction, but I would like to recall an excerpt from Abdel Rahman judgment on page 2 of our table of authorities. And I will quote 101, this a non-official translation. In this judgment, the Chamber has reached certain findings on the basis of a single testimony where it was convinced that the witness was both credible and reliable, end of quote. This applies fully to this witness, 1737, whose evidence is credible and reliable. His narrative is consistent. In fact, P1737, an OCB officer, describes the arrest of a person targeted by the charges. It is true that we do not know the name of this person, but we know his profession, which I will not state publicly for confidentiality reasons. We have also situated the date of his arrest as indicated in our submissions at paragraph 204, a date refined in light of the full body of evidence. Furthermore, P1737 provides numerous details. I refer to the transcript T44, page 42 to page 4720. He also specifies the place of the arrest. The person targeted in Incident N was arrested in the neighborhood of Bangui, an arrest during which Mr. Said was present, just as was General Rakis. And P1737, an insider witness, observed the Seleka members beating the victim with military belts, tying up in the Abacha position, and interrogating him about his links to Bouzize. P1737 said that during the acts of torture, Mr. Said and Mr. Adam were present. I refer to the French transcript, T44, page 46, line 18 to 27. The victim was locked in a basement cell, and the existence of that cell is consistent with the evidence from other witnesses of the prosecution. I refer here to 44 in the French version, page 39, line 13, and for other witnesses on the existence of this basement cell, I refer to paragraph 16, 117 and 271 and 310 of our submissions. Furthermore, the arrest and mistreatment described in the Incident L are not isolated acts. They conform to the systematic pattern that the evidence has demonstrated throughout the trial, namely arbitrary arrests, mistreatment and torture, and persecution of civilians perceived as Bouzize supporters. For example, P1737 also participated in the arrest of others.
corrobore
His testimony corroborates P1289's account of his arrest and detention. His evidence therefore overlaps with other elements in the file. Ultimately, the credible and reliable testimony of P1737, corroborated by other evidence, is sufficient to establish the accused's responsibility for this incident beyond reasonable doubt. Finally, I would like to conclude by addressing Incident H concerning the individuals arrested and detained at the OCRB after being accused of distributing a leaflet or flyer calling for a dead city operation. This incident is referred to in paragraphs 468 and 474 of the defense's written submissions. In this paragraph, Your Honours, the defense invites you to rely on Central African law to justify the lack of respect for procedural rights. However, the law is clear. The determination of the illegality of the crime against humanity of imprisonment and other severe deprivation of physical liberty is not based on national law. The third element for the crime of imprisonment under Article 7(1)(e) of the statute is explicit. What matters is that there has been a violation of fundamental rules of international law. First, with regard to the legal basis of the arrest, the defense refers to the provision in the Central African Criminal Code on acts likely to compromise public security in paragraphs 311 and 469 of its submissions. However, the evidence shows that the arrests were in fact arbitrary. For example, with regard to P1743, 0358, P2263, P2295, and P1180, 3 detainees were not informed of the reason of their arrests. P1743 said, and I'm quoting, "We did not know why we were being questioned or arrested," end of quote. And I'm referring to French transcript T086, page 32, line 2 to 4. P2263 also testified, "They did not answer when we asked them why were they taking us away," end of quote. And I'm referring to this statement, KROTP 2130, 6271, paragraph 18. P2295 testified that he did not understand what was happening. He added, and I quote, "I did not know where they were taking me. They did not tell me why they were arresting me or what offense I'd committed," end of quote. And I'm referring to his statement in French. CAR OTP 2135 1852 are paragraph 1516 and paragraph 18. As far as P1180 and P0358, even though they knew that they were accused of overthrowing the government, their arrest was arbitrary because it was politically motivated. This was in fact an act of persecution. Now, secondly, with regard to the violation of fundamental rights during detention, P1743, 2263, 2285, and P1180 were tortured and detained in inhumane conditions. With regard to acts of torture, the defense refers to contradictions. It states in paragraph 475 of his submissions that the witnesses, and I quote, "present very different versions of the violence that allegedly took place upon their arrival at the OCRB," end of quote. On the contrary, the accounts are consistent and corroborate each other. They all describe being stripped naked, forced to lie face down on the ground covered with mud or a mixture of water and sand, and then severely beaten, some specifying with whips, and P2692, who was detained at the same time, refers to the same scene in his statement. And I'm referring to paragraph 33, KROTP 2125 6685. He says, I remember another act of violence. One day, a big group of prisoners came into the courtyard. The Selika accused them of being involved in the preparation of a coup d'etat against Jatodia and in the distribution of flyers. It was before they were beaten up. The elements who said that were speaking in Songo. They asked the prisoners why are they involved in politics and requiring Jatodia's resignation. He suffered in the bushes before coming to power, and he was lying down on the face down, and the Selika soldiers threw sand and water. They were beaten on the back, and after that they were left to their thoughts. End of quote. To deny the existence of these acts of torture, the defense invokes the absence of a medical certificate in paragraph 475 of its submissions. This argument is not convincing. First, of course, it would have been ideal, but a medical certificate is not necessarily required. Article 69.4 of the statute enshrines the free assessment of evidence, and the Chamber evaluates its probative value even in the absence of material evidence. In the Ongwen ruling, for instance, in page 4 of our table, and I'm referring to paragraph 1971 and 74, the Chamber recognized rape on the basis of a detailed and consistent account without requiring a medical certificate, thus taking into account the realities of conflict zones.
En l'espèce, les témoignages.
Now, in this case, the testimonies regarding the torture suffered are sufficiently detailed and corroborated to convince the Chamber beyond reasonable doubt. Furthermore, the defense in paragraph 474 of its written submissions cites the differences in the sentences handed down by the High Court against 4 detainees to demonstrate that the process was impartial. However, no sentence, whatever it may be, can retroactively justify arbitrary arrest, acts of torture, or inhumane conditions of detention.
How much more time do you need?
I can finish in 1 minute.
Please go on.
The defense arguments are not convincing. On the contrary, the evidence in the file establishes Mr. Said's responsibility for the incidents beyond any doubt. Your Honours, in conclusion, no, the acts of torture suffered by these detainees are in no way justifiable and certainly do not fall under Central African criminal law. They are punishable under the statute of the court. They also constitute an act of persecution. The incident involving the leaflets or tracts clearly illustrates the policy pursued by the Selika to silence people through violence. Thank you for your attention, Your Honours. And after the break, it's my colleague Thomas Bifoli who will respond to the arguments put forward by the defence on the modes of responsibility.
Thank you very much, Ms. Saudachi. Mr. Prosecutor, I see you wanted to stand. Do you have anything to say or? Okay. So we're going to have a short break here, and when we come back in 30 minutes, we'll hear from the next prosecutor. Is it Mr. Bifoli? Yes, to continue with the prosecution's address. So I rise the court for 30 minutes, please. Thank you.
All rise. We would away.